Welcome once again to Lehto's Law. Here's Steve Lehto.
I've got a story here, which I believe James was the first to send me, but a lot of people sent it. Thank you very much. It's a big deal out of Ohio from the Associated Press. Julie Carr Smith wrote it. Ohio Attorney General certifies proposed ban on police immunity after loss at the U.S. Supreme Court. Prompted by a defeat at the U.S. Supreme Court, the Ohio Attorney General on Tuesday said he's putting aside his objections and allowing a proposed constitutional amendment that would end qualified immunity for police and other government employees to move forward. This is happening in Ohio. So you have to understand there's a process. If people want to put something on the ballot, they've got to do something such as draft a proposed law, go out and get signatures for it, get enough signatures in the proper places and so on, depends on the state you're in, and then it gets put on the ballot. But that process can get tricky. Because when you ask people to sign a petition and you're gathering the signatures for that, when they're signing that, there needs to be on that paper a description of what the ballot proposal would say. Quite often, there's not enough room to put the whole thing there, so they put a summary there. And then likewise, they'll put a summary on the ballot itself. And they'll often fight about whether or not the summary is an accurate summary. That's one example of things they can fight over. So here, this fight was simply about whether or not this could get certified and move forward in the election process. The AG's action came the same day the Supreme Court declined to stay a preliminary injunction issued by a U.S. District Court in Ohio, which sided with the backers of the measure that their First Amendment rights to free speech had likely been violated. Ohio's nearly century-old ballot initiative process, at risk of being permanently declared unconstitutional, caused Yost to move immediately to dismiss the appeal that he had filed in the Sixth Circuit Court of Appeals, which, by the way, is the same circuit that I'm in Michigan. The AG had repeatedly rejected proposed summary language for the measure as not being a fair and accurate representation of what the measure would do. And see, this is a problem because many people don't know the story of qualified immunity. They don't know what it means. So if you simply say, we have a ballot proposal to eliminate qualified immunity, they might need to explain what that is. And summarizing that could be a problem. Lower courts found that the AG had placed a severe burden on organizers when it came to communicating with voters and meeting the filing deadline. They also rejected the AG's argument that the case belonged to the Ohio Supreme Court. And that is an interesting argument that you'll see pop up from time to time, where there's an issue and they're fighting over the interpretation of a state constitution or something in a state constitution. And so it'll be working its way through the state courts, and somebody goes, yeah, but that also invokes the U.S. Constitution, which means that we can take it to federal court. And I've seen it before where a federal court has said, no, we're going to let the state court deal with this. But the issue of elections is something, it's a fundamental right you have to participate in the elections. So an attorney for the organizers says the AG has demonstrated that he can't be trusted with that amount of power. It's a lot of power to give any state official, especially an elected official. The Supreme Court made the right decision. So the AG issued a statement saying he planned to work with the state legislature to craft legislation to reform the ballot initiative summary process to protect the integrity of Ohio's elections and freedom of speech. The constitutional amendment would end qualified immunity, special legal protections that prevent people from suing over claims that the police or government actors or workers violated their constitutional rights. It proceeds next to the Ohio Ballot Board. And by the way, it is government workers here, but they'll often refer to people as government actors, meaning somebody who's acting in a role or a position of a government office. So they're acting on behalf of the government. Therefore, their actions can lead to something which might get them sued, and in which case they would try to invoke qualified immunity if they've got it. So there's that. But I mean, I can tell you in most recent years, there have been a bunch of these fights, including a few famous ones in Michigan. And I remember one in Michigan where they got into a fight over the font size on the circulating petitions that they're using to gather signatures to put something on the ballot. And I mean, the statute does say, that the proposal's got to be written in such a way that it summarizes properly what you're trying to put on the ballot. And then it'll say things like, and it must be written in this size font and blah, 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 blah. And it turns out that somebody, and this has been a few years, but somebody had printed these things off using some kind of word processing program. And they had chosen the correct font according to the word processor. But when the word processor then fed that into a printer and the printer printed it, if you were to compare that font size to the font size that was done by, like, say, a typesetter in the old days, actually working with, either a linotype machine or the type of set, the typeset that you'd set by hand, they were actually off by just, fractions of an inch. And then the question becomes, are we really more worried about the font size, or are we more worried about people being able to understand what they're agreeing to, what they're trying to put on the ballot? But what happened here was the AG had, said, I don't think that this is a proper thing, that this should proceed. And a court said, no, this is proper, it should proceed. And the U.S. Supreme Court took a look at it and said, we're not going to interfere. So that means that the last position it was in is how it's going to go, which, there you go. So the AG says, fine, we'll put it on the ballot. So what this means is that if you're in Ohio, at least as of right now, the issue of qualified immunity is going to be on the ballot, meaning that you can vote for this amendment that would abolish it in Ohio. And I've mentioned recently a couple times how things I like to describe as pendulums. So the mood of the people on a particular topic can go way over to one side, and you're like, wow, this is extreme. And then especially when crazy things start happening over at one end, then the mood starts swinging back the other way. So the pendulum with qualified immunity has started to swing back. And that's largely because we hear about these crazy cases where police officers apparently do things that are questionable, and people say, I'd like to file a lawsuit over that. And the court just says, no, you can't do that. And they just toss it. It'll never get to a jury, or it's going to toss it because, as a matter of law, you cannot sue them for that because of qualified immunity. So here's the thing. There's going to be a huge battle over this. You think this is a battle that made it to the Supreme Court? No. This is not the battle. The battle is going to be between now and Election Day. Because what's going to happen is all these entities with an interest in qualified immunity are all going to focus on Ohio, and Ohio now becomes the battleground state on this issue. Because if it passes in Ohio, a lot of other states are going to go, hey, we could do that too. But if it doesn't pass in Ohio, then they're going to go, hey, cool, we stopped it. But if it passes in Ohio, Ohio then becomes the laboratory. They become the experiment. We can watch what happens in Ohio. It'll take a little while, but we can watch what happens in Ohio and see if the world comes to an end or not. Because that's one of the types of arguments that the law enforcement community is going to make. And that is, if you take away the qualified immunity, we can't do our jobs, and all heck is going to break loose. All sorts of heck are going to break loose. Now, the beautiful thing about having 50 states is that when one state tries something, the other states can step back and go, hey, let's watch this for a little while and see what happens. And we'll see what happens. But I feel sorry for the people of Ohio. And here's why. Because during the election campaign that this is on the ballot for, you're going to be seeing ads on both sides put up by special interest groups who are going to bombard you with crazy messages on both sides. None of this down the middle stuff. No. You're going to be seeing ad after ad after ad that'll take this to the absurd proposition on both ends. Without qualified immunity, it will become a lifeless hellscape. And of course, with qualified immunity, we're living in a police state where they're running rampant over us. And so you're going to see, I can't even imagine what's going to happen with the advertising on this issue. It's going to get crazy. But again, it's just the people of Ohio. So congratulations. But interestingly, people got together and got enough signatures to put this on the ballot. The AG said, I don't think they've done it properly. And it went all the way to the U.S. Supreme Court. And it looks like the AG now has to back down and go, okay, we'll put that on the ballot. and see what happens. And will be interesting to see what happens. So James and everybody else, thanks for sending that from the Associated Press. Julie Carr Smith. Ohio Attorney General certifies proposed ban on police immunity after loss at the U.S. Supreme Court. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A man is also known by the company he dodges.